Ladies and gentlemen, it's our pleasure to be here this afternoon, and you have given me an opportunity that I've never had. I always wanted to cross-examine the Secretary for Justice, and I've now have the opportunity. So thank you very much, SCMP, for giving us this chance. Now, I think the Secretary for Justice needs very little introduction, and I was going to tell you a lot about him that nobody knew, but I've been enjoined from doing that by his staff. So I'll just tell you something that is on public record. A lot of you will know that Paul, as we know, was a practicing barrister. He was a busy commercial senior counsel practicing in Hong Kong before he took up this office as our Minister of Justice. Before he took on this role, he was also chairman of the Hong Kong Bar Association. So he was one of my predecessors, and has left me very big shoes to fill. So Paul, without further ado, can I dive straight in and ask you this? You were previously a practicing barrister. We have appeared against each other in court, and I can tell you that whenever I appeared against him, the result wasn't very good for myself. But now you have taken on a role as our Minister of Justice, and now we can criticize you with no end in sight. And what do you see as your biggest challenge from this jump and change of career?
Well, I think that's a very good question. As you have just mentioned, before joining the government almost a year ago, I had been practicing as a barrister for almost 28 years, something like that. And I mean, as barristers, we all know that most of the time we did legal research, we prepare written submissions, we attend court hearings. So we are very much sort of sole proprietors. But in contrast, the Department of Justice is a very big government department. And I was told that, that there are altogether almost 500 lawyers working in the Department of Justice. I was never trained, and I had no experience of running such a large organization. And I had no idea about how government actually works. So it's really a very steep learning curve, and I'm still learning. I would say that that's my biggest challenge. It's a very different sort of working environment.
Yeah. And then diving into something that is more sensitive, because he's promised me to tell us something that we've never heard before. Now, you've said that the rule of law is one of the biggest strengths of Hong Kong. I think you have used the term 金漆招牌, and that has now been our gold label that has been cited repeatedly by many people. And an important component is our judiciary, our judges. As we know, they have not been getting very good press this week as a result of a particular incident heavily featured by the SCMP. Any reaction from you?
First, you are absolutely correct that I have described repeatedly that the rule of law in Hong Kong is one of, in Cantonese, 金漆招牌. I think in English it's sort of a gold letter signboard. Now, I use this rather colorful label to stress the point that, in my belief, the rule of law is indeed one of the unique strengths of Hong Kong. Now, what you just said, I suppose you're referring to a very recent Court of Appeal case in which the Court of Appeal allowed an appeal on the ground that there was substantial judicial copying. Well, obviously that is a very unfortunate incident. But I would suggest that perhaps we should look at the matter in context, or perhaps from a slightly different perspective. Now, firstly, look at the context. Now, our legal system, our judicial system, have been in existence for more than a century. And in our legal history, if I remember correctly, and please correct me if I'm wrong, this may well be, if not the first or second case in which an appeal was allowed on such ground. And please remember, our court deliver hundreds and thousands of judgments every year. And such mistakes have been committed by some judges in other jurisdictions. And the other thing is, I'm very confident that the same mistake will not be repeated by other judges in future. Because Chief Justice had made it very clear that such conduct is unacceptable. He has reminded judicial officers and judges not to do the same. So we must not assume that this isolated incident represents any sort of general practice, because it doesn't. Now, the second point is that perhaps we should look at the matter from what I said earlier, from a different perspective. Now, judges are human beings. Sometimes they make mistakes of all sorts. In testing whether a judicial system is reliable, I think the question is whether there is an effective and open system to enable any sort of mistake made by judges to be corrected. Now, in this case, the Court of Appeal did not shy away from criticizing the judge below for making such a mistake openly. So it's a demonstration of open justice. And the second point is even more important. The reason why the Court of Appeal did not accept judicial copying is not because the judge's conclusion is right or wrong. Maybe it's perfectly correct for the judge to accept all the submissions of one party. Maybe he had arrived at the right conclusion. But the point is, it's a matter of perception. When a judge copies substantially a party's submission, there are bound to be question marks as to whether the judge had given any independent thinking to the party's submission. Now, the Court of Appeal's decision actually demonstrates that we do insist on a very important principle of common law. That is, justice must be seen to be done. So, I mean, it's a very good illustration of our insistence of some very fundamental core value of our legal system. And so, the last point I wish to make is that, at the end of the day, putting aside whether the conclusion was right or wrong, the Court of Appeal ordered a retrial. So the party aggrieved was actually given a chance to fight for justice. So looking at the system as a whole, I think it's an indication that our judicial system is working well in accordance with well-established common law tradition.
Now, this is your 11th month in this new office. So over the past 11 months, there was, if I can put it as mildly as possible, no lack of excitement. There was the interpretation under the national security law and the saga regarding overseas counsel. The primary election case is being tried in our court. And now you have made an application to file an injunction in relation to this song, Glory to Hong Kong. Now, these are obviously matters that create concerns for the business community. What are your thoughts on this?
Now, I will not describe all the things that you said to be excitements, but I do recognize that they are matters of public concern. Well, let me deal with, you mentioned three particular matters. Let me deal with them perhaps in a chronological order. The first matter is actually the interpretation. Now, as to the interpretation, we have to remember the background facts. We have a system of allowing overseas counsel who have no right to practice, who have no general right to practice in Hong Kong, to appear in a case on an ad hoc basis. Now, this is a very exceptional arrangement that is not commonly found in other common law jurisdictions. And in fact, the number of ad hoc admissions every year in the last couple of years would be around 20. So that's a starting point. And the second point is that the ad hoc admission system was built at a time long before the enactment of the national security law, and it was long before China resumed sovereignty over Hong Kong. So naturally, there was no reference to what extent national security should feature in such an application. Now, as a result of the court judgment that are well known, it was discovered that perhaps there is a loophole, put it this way, in the then existing legislative regime. Now, the NPCSC exercises constitutional power to interpret the relevant provisions in the national security law. But there are 2 points that ought to be borne in mind. First, the NPCSC, the National People's Congress Standing Committee, did not in any way overturn, change, or reverse the decision of our judiciary. And the second point is that the NPCSC did not even state affirmatively or in any way how the big question ought to be answered. That is, whether the Overseas Council should be allowed to practice in cases involving national security. Instead, it simply point out the relevant provisions in the NSL and leave it to Hong Kong NSL to decide what to do. And as a result of the interpretation, the government start to look at the then legislation to see how the regime can be improved to take into account national security. And as a result, we came up with our amendment. And under our amendment, it's not a complete ban. We still allowed Overseas Council to make an application, even though the case may involve national security. And it would be up to the chief executive to decide whether to certify that the case will be suitable for the court's consideration. And this is, once again, is perfectly consistent with common law tradition, that when it comes to matter of national security, is for the executive rather than the judiciary to decide. And even after the amendment came into effect in May, I think a couple of months, 2 months ago, and under our amendment system, which, rather speaking, can be said to be more restrictive than our previous regime, but notwithstanding that, it's still much, much more liberal than many other comparable jurisdictions in the world. Nowadays, we still welcome Overseas Council to make application to come to Hong Kong in appropriate cases, so long as they don't involve any national security. And as a matter of fact, very few cases involve national security. So that's the first matter. Now, the second matter goes to what you describe as the primary election case. Now, as we all know, a large number of defendants were involved in that case, as some have pleaded guilty. And for those who have pleaded not guilty, the trial is going on. And for this reason, it will not be right and appropriate for me to comment on the detail of the case. But I wish to just make 2 points which have nothing to do with the merits of the prosecution. Now, first, I do not think it's entirely accurate to describe the case as a case concerning primary election, because under our constitutional order, there's no such thing as a legislative primary election. The prosecution case is that the defendants were involved in an agreement to paralyze the government in contravention of a very specific provision in NSL. So whether our stance is right or wrong, and insofar as those defendants were plead not guilty, is a matter to be determined by the court. And secondly, notwithstanding this is a very important and serious case touching upon national security, we still abide by the very basic principle that the trial will be conducted in an open manner. And that's why court reporters go to court every day, and we can read news almost on a daily basis as to what evidence has been adduced before the court by the prosecution and also by the defendant, what comments have been observation made by the judge. And at the end of the day, upon the completion of conclusion of trial, the judges will give a reasoned judgment to be declared openly. So all these things are done openly in accordance, once again, the good tradition of our common law system. Now, the last matter, it's also something that is still pending.
Yes, and that is why it is topical, and I'm sure you would like to hear him on this.
Yeah, and once again, I'm sorry that I have to disappoint you. Well, I have to stress against that the reason I cannot go into detail is not because I do not have good answers. I have a lot of good answers as to queries raised by the general public, but we have to think very carefully which is the proper forum for the government to state its position. Now, the reason why, I mean, Victor, you're a barrister, you're very familiar with the principle of sub judice, and that's why the Bar Association refused to comment on the issue. It is exactly for the same reason. The rationale is to preserve the integrity of the judicial process. We do not wish to make our court comments, which might be misconstrued as any sort of attempt to influence the court. All our submissions, our stance, the evidence that we intend to rely on, all our legal arguments will be submitted to the court openly on the 21st of July. And what we did last week, which is also an important point, is that we have made an application to the court, and the court had allowed us to publish the key legal documents, including the terms of the injunction that we are seeking by various means, for example, by posting it on government's website. The purpose is to invite parties who are interested, including those who disagree with the government's application, to come forward and to take part in the legal proceedings. So they are given the chance, they are given the right to be heard. If they disagree, perhaps I would invite them to meet us on the 21st of July so that we can set out our respective arguments before the judge and let the judge decide.
That's it.
Yes, for today.
For today.
Well, what Representative, I added the point. I think that that's something that the chief executive has said. The whole injunction is concerned with a very specific song, which had been misused and misrepresented as the national anthem of China. And it also been misused to promote independence for Hong Kong. Now, as a matter of principle, this is wholly unacceptable. And I think the government position should be and must be understandable. And secondly, when it comes to the injunction that we are seeking to restrain very specific type of activities, which may well constitute criminal offenses already. So those sort of activities are not matters that I would have thought that ordinary people would be interested in doing, and it's not something that they have been doing. So I do not see why ordinary law-abiding citizens should be worried or concerned about the application. So it falls within a very narrow compass. It's very focused on very specific type of activities. I think these are the points that I wish to make. The details, I'm sorry, that I have to leave it to lawyers to be made before the court.
Okay, and now let's move on to something that affects me personally. We know as a matter of fact, and we have many business leaders and consulate generals here, many American and European businesses, and even some Asian countries, they are avoiding Hong Kong as a seat for arbitration to resolve their dispute and differences. I mean, how do we address this problem? And are you still optimistic?
Now, firstly, I'm not sure, well, I will not question what you had just said. I've heard some incidents in which people decide not to come to Hong Kong. But to what extent that represents a general trend, I cannot tell. But I'm very prepared to face the music. Firstly, we are facing very serious challenges because of geopolitics. And from time to time, we have seen rather inaccurate, false, or even malicious observations or comments against not just our legal system, even against our judges or judiciary. So I think the first thing is we must take a more proactive approach. It's not just for me as the Secretary of Justice. For example, the legal practitioners also play a very important role to correct people's misconception about our legal system. But the substance is important, the substance. What am I going to convince people that those statements are untrue? Now, I think there are a number of things that we can say. Firstly, we still have a very independent legal system. All the guarantees under common law remain unchanged. And I do have some very good evidence as to why our judiciary is very independent.
You're going to tell us you just lost a case, right?
Well, not just one. Well, we just lost a case in the CFA not too long ago. That is a very, there's a case very, should be familiar to reporters or to journalists. We succeed in the court below, we won in the magistrate, we won in the high court, and the Court of Appeal unanimously allowed the appeal. So although the court accepted some of the submission, I think we lost. But last week, I was told yesterday that in another judicial review, a court of first instance case, the government lost again. So I think these are very clear incidents that the judiciary are exercising their independent power of adjudication as in the past. And when it comes to, you mentioned arbitration, I think there are a lot of attracting features of Hong Kong. Hong Kong has been very proactive in making arbitration user-friendly. You are very active in arbitration, both acting as arbitrator and as counsel. So you must be aware of the fact that in the last couple of years, we have made several important amendments to our arbitration law. For example, we allowed third-party funding, and last year we allowed more funding options by allowing parties to enter into a fees arrangement which depend on the outcome of the case. So we're maximizing funding option to ensure that clients will have more flexibility in deciding how to conduct their case. And another very unique feature, which you cannot find anywhere, is that Hong Kong has entered into a couple of very important mutual legal assistance arrangements with the mainland. There are three concerning arbitration. I just cite one example. There's a very important arrangement concerning mutual recognition and enforcement of interim measures in arbitration. So for example, if I'm a party in arbitration, my opponent happened to be a party in the mainland or has access in the mainland, my primary concern is that pending arbitration, which can be time-consuming, whether I can take some interim measure to safeguard my position, for example, to freeze the access to my opponent, to restrain my opponent from conducting allegedly wrongful behavior in the mainland, then they can do it in Hong Kong. They can go before the Hong Kong court, apply for interim injunction, and then armed with that Hong Kong court order, they can go to mainland court and ask that Hong Kong court order to be recognized and enforced. So this sort of very close and important and practical mutual legal assistance arrangement can be found in Hong Kong and cannot be found anywhere else. And another point that I also wish to mention is that we have a large pool of legal experts, including, for example, people as eminent as Victor. We are, not only that we are bilingual, we are very familiar with the Chinese culture. We are very familiar with how things are done in the mainland, because very often international matters involving litigation, arbitration, or mediation, one of the parties would be related somehow related to mainland. And in order to receive a proper and detailed legal advices, it would be a huge advantage if you can receive assistance from a legal expert who doesn't simply know about the common law, but who is also familiar with the legal and business culture in the mainland. So I think that is also a very important factor that ought to be borne in mind. But I'm not suggesting that you must choose Hong Kong or Chinese local. We welcome arbitrators, lawyers, parties coming to Hong Kong. And we have just introduced a new measure. The government introduced a new measure from 1st of March. We have provided more immigration convenience to parties taking part in arbitration, no matter whether you act as arbitrators, counsels, or witnesses. Putting aside other restrictions, you don't have to apply for a working visa if you are engaged in arbitration. So we are thinking ways to make it a more convenient and user-friendly process. So lastly, look at the reality. I think most investment opportunities and business opportunities can be found in mainland China. And as to where you should choose to be the place to resolve dispute, it's a matter of negotiation. And obviously, the two contracting parties may have very different views. But Hong Kong, I think, is a perfect choice for a deal involving a foreign party and a party involving mainland, which is very often the case. Because on the one hand, Hong Kong practices a common law system. We are very international. So we are using a system which is familiar to the international business community. But on the other hand, from the viewpoint of the Chinese mainland party, Hong Kong is a part of China. We speak Chinese, we are bilingual, so they would certainly feel more comfortable if Hong Kong can be chosen to resolve the dispute. So in a sense, Hong Kong suit the needs of both parties, though perhaps for different reasons. So I think if you combine all the factors that I mentioned, I would say that Hong Kong enjoy a very unique advantage as compared to our competitors.
Yeah, thank you very much, Paul. The role of the Secretary of Justice has been described as the guardian of public interest, and I think you would all agree in times like this, the task of our SJ has been more difficult than ever. So thank you very much, Paul, for taking up this job And I hope everyone can join me with a big round of applause for our SJ.
Thank you, Victor. Thank you for having me. Thank you.